Thank you, Madam Speaker. I wanted to give you a brief update on the investigation. In the last couple of weeks, I think we've made dramatic progress in answering some of the questions surrounding that July telephone call between President Trump and President Zelensky, in which the President of the United States sought to coerce a vulnerable ally into conducting, I think, what can best be described as sham investigations involving his opponent and involving a debunked conspiracy theory about the 2016 election. We have learned that call was not in isolation. There was a great deal of preparatory work that was done before the call. There was a lot of follow-up work that was done after the call. And we have learned much of this thanks to the courageous testimony of State Department officials who have been put in an impossible situation by the administration, and that is urged not to comply with the law, urged not to comply with a lawful subpoena by the U.S. Congress, and they are doing their duty. And people should make no mistake about that. They are doing exactly what they are required to do. And I think showing enormous courage. And I think we owe a great debt of gratitude to public servants like Ambassador Yovanovitch, who had to endure so many false smears on her character, and has continued to show the courage to come forward and speak to our committees. And we are also learning a great deal on the issue of conditionality. That is the effort to condition a White House meeting that was desperately sought by the Ukraine president in order to get a commitment from that president to do these political investigations on behalf of the President of the United States. So we are learning a lot about the conditionality of that meeting, and I want to underscore just how important that meeting was for Ukraine. It is, I think, at the very top ask of most countries to have a meeting with the President of the United States, but this is most particularly true for a country that has been invaded by its neighbor, Russia, that is in the midst of still a very hot conflict that is dependent on us economically, politically, diplomatically, militarily, to show that the new president had a good relationship with the President of the United States. And so that gave enormous leverage to President Trump to coerce what he wanted from the President of Ukraine. And what is so damaging about this is at the very time the State Department is trying to urge Ukraine to follow the rule of law, you have the President of the United States urging that president to engage in political investigations. You could not have a message more contradictory to that of the State Department than that we saw in that call. So we've been bringing witnesses in at quite a furious pace. That pace is only accelerating. We've got a very busy few days and weeks ahead. But we are running into what we expected in one aspect, and that is a complete effort by the administration to stonewall. Today is long past due, the date when the State Department was subpoenaed to provide documents. The State Department has requested of those that we have contacted that instead of giving the documents to us, that they give the documents to the State Department, under the expectation, I think these witnesses had, that the State Department would turn them over to Congress. But the State Department has thus far refused. And were it not for the fact that at least some witnesses have given us documents, we would not know that there is a paper record of efforts to condition this meeting and perhaps condition military support itself on these political investigations Donald Trump wanted. Those documents would have been completely bottled up by the State Department. We know from the witnesses who have come forward that there are additional documents that they have provided the State Department that have not been given to Congress. And so the evidence of obstruction of Congress continues to mount. Today was the deadline for the Office of Management and Budget and the deadline for the Pentagon to provide us documents. The Secretary of Defense on Sunday stated that he would comply with the congressional subpoenas. Well, apparently his willingness to comply has now been countermanded by a higher authority. We must presume that the President of the United States has instructed the Defense Department not to comply or has done so through the White House counsel, notwithstanding the Defense Secretary's willingness to comply with lawful process. The Office of Management and Budget had a pivotal role in the suspension of that Ukraine military assistance. They refused to provide the documents that would give evidence as to why that was being done. And so the case for obstruction of Congress continues to build. But even as that case for obstruction continues to build, we are nonetheless continuing to get good and important information from these courageous witnesses. And I'd be happy to respond to a couple of questions.
Mr. Schiff, and I'd like to hear from the Speaker as well on this vote.
Why you find it important to keep this portion of the inquiry happening behind closed doors, and at what point will you bring the American people into this process? At what point will you show them your work product?
Yeah. Well, that's a very important question, and I think people need to understand the fundamental difference between where we are today with the Ukraine investigation and how the Russia investigation was conducted, how the Watergate investigation and how the Clinton investigation were conducted. In each of those cases, there were either independent counsels or special prosecutors doing the investigation, doing the initial investigative work, and that was all done behind closed doors. And it was done behind closed doors for a reason by those special counsel, and that is there is a profound investigative, not only interest, but need to make sure that one witness does not have an opportunity to read another witness's testimony and either hide the truth or color the truth or know just how much they can give and how much they can conceal. I'm sure the president would like nothing better than to have witnesses have the advantage of what others are saying. But there are reasons why Special Counsel Mueller did his investigation before a grand jury and not in public sight. There are reasons why the Watergate and Clinton special counsels did their investigation in like manner. There is no special counsel investigation going on of the president's misconduct vis-a-vis Ukraine. None. Congress has to do it. And the reason there is none is because Bill Barr's Justice Department, when a referral was made to the Justice Department, said, there's nothing to see here. And we don't even want to look, because the fundamental attitude of the Attorney General is the president is above the law. Well, the president is not above the law. But it has forced the Congress to do the initial investigative work that normally a special counsel would do. So there are good and sound reasons. Now, I should tell you that notwithstanding those good and sound reasons, at each of these committee interviews and depositions, and when we get to open hearings, and we will get to open hearings, the Republicans are completely represented. All of the members of these three committees have been invited to attend and participate and ask questions. Their staff have been invited to ask questions. And indeed, we have been alternating 1 hour for the majority, 1 hour for the minority, 45 minutes for the majority, 45 minutes for the minority. They have been largely staff-conducted interviews. They've been very professionally done, although members too ask questions. And we go until the questions are exhausted. So they get to ask whatever questions they want in a process in which they have every bit as much opportunity as the majority to ask questions. And so people need to understand, notwithstanding, I think, some of the representations to the contrary, there is full participation by the GOP in each one of these interviews and depositions, and there will be in the open hearings. Now, we do anticipate a time when we'll be releasing transcripts, and we do anticipate there'll be a time when we may call back some of these witnesses for open session, and we may call witnesses in open session that we haven't called in closed session. But we will do so giving the GOP members every opportunity to ask questions. And we will also do so, though, mindful of the needs of the investigation, because, we are not unconscious of the fact that people have come before our committee and lied to our committee. One has pled guilty to lying to our committee, Michael Cohen. One is in trial, charged with lying to our committee. And we want to make sure that we get to the truth, and this is the process, I think, early in an investigation that makes the most sense.
Mr. Chairman,
Yes, sir.
There's been some concern that the White House would invoke executive privilege to keep some of your witnesses from testifying fully. I know you don't want to go into the content of what people are telling you, but can you say if all of the witnesses who've come before you thus far have been fully cooperative? Are they able to answer every question and not being prohibited from doing so once you get them in the room?
They have been fully cooperative. They understand their legal obligations. they have often sought guidance from the White House. Are you invoking a privilege? Where is the DOJ opinion, which usually accompanies the invocation of a privilege, setting out specifically what questions you believe would call for the elicitation of privileged information? The White House doesn't want to do it, and they haven't done it. So they've really given no specific guidance to these witnesses. And, part of this, I think, is designed to try to intimidate these witnesses and say, we're not going to tell you what may be privileged. We want you to take the risk. It's a way of trying to chill them from cooperating. Now, it's not working, but I think that's the goal. And, we have seen a White House counsel take the unprecedented position that not only is a direct conversation with the president privileged, but even a conversation with Donald Trump when he wasn't president is privileged, according to this White House counsel. Even a conversation with someone who never worked for the president is privileged, or could be, according to White House counsel. Even a conversation in which two people, neither of them are the president, may be privileged. I mean, it's unrecognizable. Our conversation may be privileged, according to the White House counsel. I hope not too. But it goes to show the legally insupportable position of the White House. And indeed, you see this now reflected in court decision after court decision after court decision, where judges have said the administration's legal arguments hold no water. But what they are succeeding in doing is building a case involving obstruction of Congress.
Mr. Chairman, Mr. Chairman.
The White House says it's not cooperating in part because there hasn't been a vote to formalize this impeachment inquiry. Why not hold the vote and call the White House bluff?
Well, I'll let the Speaker respond to that, but I think the Constitution is very clear. The House will have the sole power of impeachment, and there is no court that's going to find otherwise. And I think the Republicans know it, but they don't want to discuss the president's conduct. They would much rather discuss process, because they can't defend the president's conduct. And every time they're asked, you see just how difficult, how indeed impossible it is to justify the unjustifiable.
As the distinguished chairman said, there's no requirement that we have a vote. And so at this time, we will not be having a vote. And I'm very pleased with the thoughtfulness of our caucus in terms of being supportive of the path that we are on, in terms of fairness, in terms of seeking the truth, in terms of upholding the Constitution of the United States. Thank you, Mr.
If I
Chairman.
can follow up on that point, that's a very key point, though, and as the chairman says, the Constitution, Article 1, Section 2 and 3 are clear about what bodies have power
Right.
of impeachment here. But that said, when you hear from your caucus, we're not ready to have a vote yet, why not call the administration's bluff and say...
Why? Because we're not here to call bluffs. We're here to find the truth, to uphold the Constitution of the United States. This is not a game for us. This is deadly serious. And we're on a path that is taking us to a path to truth and a timetable that respects our Constitution. I'll remind you that this news broke on September 17th, Constitution Day. Constitution Day, the day our Constitution was adopted in 1787. It broke that the president had violated his oath of office to protect, defend, and preserve the Constitution of the United States to the best of his ability. So we are honoring our responsibilities. We are honoring the Constitution. That's not what they're doing.
Are you concerned about them trying to...
I'm not
dictate
concerned
the
about
investigation?
anything. They have no substance. They can't defend the president, so they're going to process. We're not going there. Thank you all very much.